My name's Aaron Bundy. I'm a lawyer licensed to practice in Oklahoma, the District of Columbia, and New York. I represent individuals in criminal defense cases and individuals involved in contentious family and matrimonial matters. I'm talking today about executive compensation, and I first want to talk about what I mean when I say executive compensation. So if you are a key or highly compensated employee or a C-level executive, you may tune out for the first minute here while I do an overview for the outspouse or their attorney about the concepts I'm talking about today. So when I talk about executive compensation, I'm distinguishing that between or from other types of deferred compensation, such as pension plans and 401k plans. Those are important assets, but when I say executive compensation, I mean the type of plans and compensation that go above and beyond the pensions and 401k plans that are typically available to all full-time employees at an organization. Those plans, pensions and 401ks, are governed by ERISA, and companies are not allowed to discriminate in who they offer those plans to. So all the employees generally have the ability to participate in those plans. Unlike ERISA qualified plans, executive compensation plans are typically designed for a small group of individuals, maybe even a single person, to incentivize that person or that small group to perform at a high level and to retain them, to keep them at the company. Companies do that in a couple of different ways. There are a multitude of different types of executive compensation plans. Most of them involve some type of equity or ownership in the company. A common executive compensation plan includes a structured stock ownership plan with a vesting schedule. So in that scenario where there are potential stock options, the employee, there are a number of benchmarks set in the plan. They can vary. Some of them, a basic stock option plan involves tenure. You do not acquire an interest in these stock options until you've been with the company for a certain period of time. So there's a vesting schedule there. The significant thing about stock option plans, especially in the context of a divorce, is that you may acquire an interest in a stock option that has not yet vested. An interest in stock options that is contingent on something else, such as performance that's been identified in the plan or tenure and continued stay with the company. However, under Oklahoma law, that concept of whether a plan has vested or is contingent on something is largely irrelevant in a divorce case. If the interest has been acquired, even though it hasn't been fully vested, then that has been viewed by Oklahoma's courts as a valuable right acquired during the marriage that is subject to division in the event of a divorce. How can they do that? That can be a difficult challenge to undertake because they haven't vested, and so it's difficult to determine the value of those shares because they have not vested yet. They cannot be sold or traded. So there are a number of creative ways that experts use to determine values, and it's not necessarily going to be divided on a 50-50 basis because of the tax ramifications and the uncertain nature of the stock options, because the contingency, the vesting of those stock options has not yet occurred. The biggest question when it comes to executive compensation plans is, was it acquired during the marriage? Is it income that's earned during the marriage? Because future earnings are not divisible in the event of a divorce. In the example I gave about stock options, the dispute in the cases that appellate courts have heard has been whether the stock options have been earned because they have not vested or contingent. And again, the courts have held that that's largely irrelevant. The stock option interest was acquired even though there is a vesting schedule and it hasn't vested, so that's going to be subject to division in the event of a divorce. So why do we have executive compensation plans? Because there are limits to what an individual can contribute to a more ordinary qualified plan, such as a 401k. In 2023, the limit to contribution in a 401k for an individual is $22,500. The idea behind deferring compensation to later in our life is so that we can enjoy a certain standard of living in our retirement that may be comparable to how we lived when we were working full time. So for a highly compensated or a key employee that makes 7 figures, maximizing their contributions to their 401k and Social Security is not going to be enough for them to be able to live at a level that's comparable to the income they received when they were working full time. So an executive compensation plan can be attractive to the company and to the executive for a number of reasons. It is a way for the company to single out this group or individual and say, we are going to give you additional income. We're going to defer it. There's going to be potential tax benefits to you. And later in life, when you retire or leave the company, you will have this additional compensation in addition to the 401k or pension plan that everybody at the company has. The other attractive thing about these kind of plans for companies is that because they are non-qualified and because the company can discriminate and only offer it to a select few individuals, they can get really creative in terms of how they're structured and what the plan entails. What are the contents of the plan that will draw the employee, that will attract qualified workers, and that will keep them there and motivate them to work at a high level? Some of the things about these plans that make them really attractive to both the company and to that executive also make them difficult concepts and issues that need to be addressed in the event of a divorce. Here's why. A lot of times, this compensation is not going to show up on that executive's regular pay stubs. It may not even show up on their tax documents that they receive end of year from the company. So you cannot afford, if you're the out spouse, if you are not the executive and you're involved in a divorce, you can't afford to assume. You can't afford to take anybody's word for what is and is not there. And you can't just rely on earning statements and even the tax documents that have been distributed from the company. You have to conduct some thorough, extensive discovery. It will be very important for both sides to add to their legal team the services of a qualified financial expert and a tax accountant to identify the documents that they need to look for, acquire those documents, and then appropriately analyze them. There are several horror stories about large corporations, even publicly traded corporations, that have effectively 2 plans. One plan is the one that they identify for public disclosure that's required by SEC regulations. And then there's the real plan that truly identifies the agreement between that executive and the company and that more accurately sets out what their compensation and what their benefits are. So in those kind of circumstances, you need to know that. You need to have people engaged who are aware of that possibility, and you need to have experts on your team who can help you acquire and analyze those documents. Now I'm going to talk about a potential exception to everything that I've just said. In review, I talked about how stock ownership plans, those incentive structures, have been identified as marital property by Oklahoma courts, even when they have not vested or are not contingent. To set the stage for the potential exception that I'm going to talk about, when a divorce petition is filed and the respondent has been served with that petition and summons, a special court order goes into effect called the automatic temporary injunction. The automatic temporary injunction contains a number of do's and don'ts. One of the don'ts, one of the prohibitions in the automatic temporary injunction is forbidding either party from altering or withdrawing from a life insurance policy, from canceling that policy, or from changing the beneficiaries. However, on at least 2 occasions, Oklahoma's appellate courts have taken great lengths to avoid consequences for spouses who violated the automatic temporary injunction during a divorce, changed the beneficiary from their spouse to someone else, and then passed away. The beneficiary that was named in violation of the automatic temporary injunction received the full benefits of the policy, and the spouse who was originally the beneficiary in the policy is left without any remedy under Oklahoma law. Now, this commentary cannot be received and should not be received as a license to violate the automatic temporary injunction. However, against the backdrop of those appellate cases, in the context of divorce planning, executive compensation plans that are based around cash value whole life insurance policies or universal life insurance policies may be more attractive than other types of plans that would require notice to the spouse or beneficiary in the event of a change. This anomaly in the law is important to know for executive compensation and if you're going through a divorce. Life insurance policies are private contracts between the policy owner and the insurance company. When a divorce is underway, access to information typically changes, becomes more difficult and more formal through the discovery process. As a practical matter, while the divorce is going on, it may be difficult, if not impossible, to learn in real time about any changes made to the beneficiaries of a life insurance policy, even if that's done in violation of the automatic temporary injunction. For all kinds of deferred compensation, including these executive compensation plans, take care not just to place it on a balance sheet side by side with other assets such as cash in financial accounts and equity in real property. They are not the same dollar for dollar, and these kind of plans will need to be tax adjusted by a qualified expert so that you can make a real assessment of the entire marital estate. Depending on the type of plan, the ages of each spouse, and other circumstances, there may be tax consequences and even penalties for early withdrawals from many different types of plans. So it's important to engage the services of a qualified tax accountant when you're reviewing plans of any kind, including regular pensions and 401ks I talked about earlier, as well as these unique customized plans designed for key employees and highly compensated employees.